I'm pleased to have you at the summer school here tonight. Thank you, Monica.
Good evening, everyone. It's great to be back at McGee. Many years I taught, actually when there were very few classrooms at one time, I actually taught in this very hall. I used to travel down from Jordanstown. I want to thank Professor Gillian Robinson for inviting me to give the summer school lecture, and the directors of the Transitional Justice Institute and Brandon from INCORE. It's great to be here for the 2010 summer school. I feel I'm amongst friends. I certainly am amongst my old colleagues, and I want to thank Professor Barnett and Dean Anne Moran for releasing me all those years ago to do what I am now doing and to be able to fulfill my commitment and my duties to the Human Rights Commission. And I promise you one day I will return. Again, I look down this hall and see many friends. John, Hume and Pat, very dear friends throughout those peace negotiations. Tonight I met again Archbishop Jim Mahaffey and Joan. The last time we met, we were partying in the White House when President Clinton used to throw really good parties. And then we had a rather different kind of breakfast with President Bush. We will say no more about that. But many of you know me, and it's great to see you all. I see Paul at the very back, and Brendan, and many of you who I've taught for many years here at the university. But let me start by telling you that my daily work at the Commission consists in trying to apply every day the principles of human rights to the realities of our very modern society now in Northern Ireland, albeit a society that has experienced a terrible and very long period of violent conflict, but also now confronts the same demands as any modern democratic society. This is a practical and necessarily pragmatic professional task. However, I also believe that human rights are the very basis of the way that we must live together as human beings. For me, human rights are the very basic concept of our humanity. So in that context, I want to begin by telling you a story about a British soldier who once found himself being trained by our Commission a few years after the Good Friday Belfast Peace Agreement. In 1999, the year following the agreement, we had 15,500 troops here on our streets, half of the peak levels of the early 70s, but still a substantial military presence, particularly when they were working alongside 12,500 fully armed police officers. But it wasn't until January 2004 that the Human Rights Commission secured its very first meeting with the Army. And as you can imagine, the training started with a bit of a culture clash between the soldiers and the staff. So over the lunch break, a very young officer was heard to remark, "It's all very well, this human rights guff, but if you ask me, the only human rights that you need in the modern world today are the right to private property and perhaps the secret ballot." Now, the Human Rights Commission staff had to swallow very hard, but he replied, "Well, up to a point, but what about the right to life?" The young officer thought for a moment and said, "Yes, of course you needed the right to life, because without it you couldn't vote or own property. But of course," he added, "that's the sort of thing that you really only need in a third world country." The young officer may not have noticed, even back then, that people around him were so worried about what had happened to 13 people who had been shot dead by the Army here in this very city. The cost of the Bloody Sunday inquiry stands at £191 million, and now, 12 years later, after its commencement, the Saville report will finally be delivered in this coming week in this city. Brendan Bradley, a friend and worked for victims in North Belfast and sadly now deceased, once remarked that the troubles in Northern Ireland had taken slices of his family. And there is no doubt that that violation to the right of life here in Derry on Bloody Sunday took slices of this community, and the impact of those events resonated throughout the whole of our society. I'll return to the issue of victims later, but for the moment let's go back to the Commission again and to the trainer who in that session was sufficiently emboldened by the officer's concession to run the whole gamut of human rights past him. What about the freedom from torture, he wondered. Torture, yes, obviously. The lieutenant conceded. We couldn't allow that, absolutely not. Now this was January 2004, remember? a whole 8 months after the death in Basra of a 26-year-old hotel receptionist called Baha Musa, which had also led to another public inquiry that's currently sitting in London. Baha Musa had ended up in British Army custody, and in a case taken to the House of Lords, the judges confirmed that the very fact that he was in British custody entitled him to the protection of the European Convention on Human Rights. But if instead of enjoying that protection, Mr. Musa was hooded, forced into stress positions, deprived of sleep and beaten for a day and a half, before dying with 93 visible injuries on his body. Several of the techniques used against that young Iraqi man had been pioneered by the army and had been pioneered here in Northern Ireland. The government of the Republic of Ireland brought the United Kingdom before the European Court in 1971 in a case in which the 5 techniques developed in the fight against terrorism were judged to be so harsh and so brutal that the UK state was found guilty of breaching Article 3 of the European Convention, which refers to inhumane and degrading treatment. This was the sort of treatment that had killed Baha Musa. We had no Human Rights Commission back in 1971, but now we have. And a statutory commission in Northern Ireland or in Britain should be just as ready as any of the NGOs to react to the judge's ruling that the atrocities committed 35 years ago are still atrocious and unrepeatable today. So in this respect, it's worth inquiring, like the Chief Justice of South Africa, Arthur Chaskalton, has done this week. But where were the physicians for human rights when these torture techniques were being developed? It was also good to see that in that House of Lords, jurisdictional ruling was also raised, that the European Convention means and has to apply to soldiers in the United Kingdom or wherever they're stationed throughout the world. When I first took up my post, this jurisdictional issue also arose when I sought assurances from the UK government that extraordinary rendition was not happening in Northern Ireland when American aircraft were using any of the UK airports. Similarly, the Irish Commission asked for the same assurances about Shannon Airport, and we supported them in our joint committee meetings when this became a controversial issue. Uniquely, in the world of national human rights institutions, and as a result of a mandate from the 1998 Belfast Good Friday Agreement, both the Northern Ireland Human Rights Commission and the Irish Human Rights Commission have to meet jointly, and we do so on issues of cross-jurisdictional impact. Now, unlike some other commissions, neither the UK, none of the UK commissions or the Irish Commission has the power to enter military establishments, although we do have the power to enter places of detention. Now, as a result, we were dependent on monitoring the government's response, and it's clear that in the absence of an independent monitoring body, the people are unlikely to trust the assurances given by government in relation to this or any issue, but particularly the issue of extraordinary rendition. So the point I'm making here is that when a country is in conflict, an independent monitoring body is a vital tool in building or re-establishing trust so that the state can be trusted to exercise its authority in compliance with international human rights standards. But again, let me go back to that training session with the soldiers in Northern Ireland in 2004. Our trainer again posed the question, would you say that children have the right to education? And the soldier instantly replied and agreed. And so the conversation progressed until he conceded the human right to clean water, the right to a fair trial, freedom of religion, and the prohibition of slavery. He allowed that there was even a right to privacy, to decent housing, and to the freedom of expression and assembly, within sensible limits. So over the course of the next few minutes, he became quite the enthusiast for human rights. You know, he said, those are the sort of values that I joined up to defend. So why then was there such a reaction to Chris Patton's recommendation to put human rights at the centre of policing back in 1999, when his commission reported on the future of policing in Northern Ireland? And why did it take so long for officers to be exposed to explicit human rights training? So the point I've been emphasising throughout this story is that certain basic rights are intrinsic to the notion of humanity, in both times of war and times of peace, and that both civilians and combatants have to be mindful of that. A second important point about human rights is that they should form the foundation of the social contract that exists between the people and their government. And here I want to tell you another story to show what I mean by that statement. This one involved a politician who was questioning the Commission and our support for cases involving the human rights of prisoners. Again, our staff had to explain how prisoners may lose their right to liberty, but they don't lose any other human rights when they go in through that prison gate. When people are particularly vulnerable or in places of detention, the state owes them a particular duty of care to ensure that their human rights are protected because of that social contract between a government and its citizens. Again, there is a crucial role for a national human rights institution to play in upholding and holding the state to account for these rights and freedoms. You may be aware of the current protests by Republican prisoners in the separated regime in Row House in Maghaberry. When the Commission was alerted by family members recently and by the legal representatives about this matter, the human rights concerns were first raised by me with the Minister of Justice and with the Director of the Prison Service. In this instance, we also engaged with the Prisoner Ombudsman, Polly McCabe, who had received a number of individual complaints from the prisoners and whose job it is to investigate these complaints. It's important that each agency, the Prisoner Ombudsman, the Criminal Justice Inspector, we and the Human Rights Commission, understand our respective roles when crises like this happen, so that it's important that we don't duplicate each other's functions. It's also very important that families who don't understand who's responsible for doing what, when and where are kept in regular contact. The Commission does have the powers to access places of detention, but we can't go in unannounced unless I declare a full investigation, and then I have to wait 15 days after I share the terms of reference with those who I'm about to investigate. So in some ways this is considered a fettering of our powers, and I hope one day that those 15 days will be raised. However, when I asked the Chief Constable last year to give me permission to go down to Antrim Custody Suite, following the detention of 12 individuals under the Counter-Terrorism Act, he understood but didn't require me to call this full investigation in order to give me that access. On that occasion, I entered the police station a few hours after the request, as the Commission's investigators needed to monitor the conditions without giving too much prior notice. The Commission had previously raised these human rights concerns regarding 28-day detention without charge, and had made it clear that this was a retrogressive step in a place like Northern Ireland. In addition, we were also aware from our previous visits to Antrim Custody Suite, where we'd gone there to view conditions for immigration detainees, that the police station didn't have the appropriate facilities to accommodate large numbers of individuals in detention for a period greater than 3 days. Now, clearly some of you may have read the media responses to that visit at that time. These are difficult issues to clarify with a hostile media at a time of a political crisis. But nonetheless, a national human rights institution will be tested at a time of such crisis, and its independence must be asserted and should be respected. But even where political opinion is against an intervention on human rights ground, a national institution still must act. Human rights are not a popularity contest. They're non-negotiable, and their access and success must be measured against a capacity to uphold human dignity, even if not especially for those who are stigmatized, demonized, or even vilified. So I'd suggest that human rights are worthless if those charged with their oversight fail to act in the face of public opposition. At times like this, it's not always easy to keep some of the commissioners on board, particularly if, as there always will be, political parties asserting influence from outside. That is why an independent appointment system to national human rights institutions must always remain a precondition. Where there is undue interference in the work of a national human rights institution, then the accreditation to the United Nations Coordinating Committee is put in jeopardy, with the possibility that my commission or any other national human rights institution will lose its standing in the international world and be severely criticised by other countries. This is the penalty that the government must be prepared to pay if it decides to make its appointments political. And it is also the case that the Commission in Northern Ireland has to be as representative of the community as practicable. But that does not mean that it has to be political. The example of the Timor-Leste Commission is worth noting in this respect. The Timor-Leste Commissioner for Human Rights summoned the President and the Prime Minister to his office following the outbreak of serious civil disturbances in East Timor last year in 2009. The Commissioner asked them to account for their actions and informed them that he would be monitoring their respective roles as Prime Minister and as President in relation to any other disturbances. Actually, when he told me that, I used to sit and think, what would it be like to call First Minister and Deputy First Minister to my office and ask to account for certain roles. But anyway, as a consequence of this strong, independent, authoritative and respected voice, this national human rights institution is seen as a model of transitional justice, and it is seen as to be working effectively. When I visited the Chief Commissioner in his office in Delhi, I observed outside his room that morning a 24-hour bodyguard, and was informed that his responsibility for monitoring corruption in East Timor had led to threats on his life. Since he was to lose this function for monitoring corruption, he wasn't too worried about this threat. But the question for me that morning as I left his office was, did the monitoring role for corruption mean that his life was in danger rather than his monitoring role for human rights? The Commissioner will be visiting us here in October, and I'd be delighted to bring him to both INCORE and to TGI, where we can perhaps have that discussion between corruption and human rights, and which creates the biggest death threat in a country coming out of conflict. So these two ideas, however, that rights are intrinsic to our concept of humanity, and that they're the very basis of a social contract between the people and their government, are core to a peace process. A society that's at peace with itself and a society that's built on justice have to be truly transformative. When a ceasefire is declared, it's generally because one or both sides agree that there'll be no winners in continuing with the military campaign. William Sartman refers to this as a mutually hurting stalemate. And according to Sartman, each party must begin to feel very uncomfortable in the costly dead end that it has reached. This plateau must be perceived by both sides, not as a momentary resting ground, but as a flat, unpleasant terrain stretching far into the future, providing no later possibilities for escalation or for a graceful escape. So did that happen in our own situation? Certainly there were no victors where paramilitary organisations on the ground continued to face security forces and army personnel relying on local intelligence for successful engagements. What the ceasefires have told us and what has been acknowledged was the need to finally declare a draw, halt the military-paramilitary action, and enter a political process in which the legitimacy of each side would be finally recognised. I know how difficult that is. I sat for 2 years at the peace negotiations, and who permitted who to have legitimacy in such a situation can be a very difficult issue to resolve. But as George Mitchell told us, not to resolve it can mean that violence goes on with the increasing loss of life, and the intransigence just takes away the people's hopes. The main apprehension of political parties in these circumstances is that gunmen outside of the negotiating rooms may determine both the direction and the pace of subsequent negotiations. And for this reason, a mechanism had to be found that will encourage a sustainable ceasefire, imply a substantial sense of democratic credibility to the negotiators, and provide a method that will constrain any further paramilitary action. In Northern Ireland, the Mitchell Principles, named after George Mitchell, were introduced in 1996 to address these concerns, and before the participants, including myself at that time, were admitted into the negotiations, we were required to agree to these principles. During a conflict, all sides tend to deny the common humanity of the other in the belief that the other side doesn't deserve human rights because they're somehow less worthy or demonised as being less human. And I have to say that I watched that, observed it for 2 full years at the peace negotiations. But I also want to add that there are other groups deserving of human rights who have felt that experience. Women also know this because they have been used and abused as being seen as less deserving of rights, particularly in conflict situations. In the aftermath of conflict, and especially in a peace process, the human rights in which the peace process has to be grounded have to have the reassertion of human rights. These rights have to be restored, not just for the main religious groups, but for ethnic minority groups and also for women. And I'm sure Patrick Hughes, who is here from the Ethnic Minorities Association, would agree with me on that point. In this very clear and overriding sense, the re-establishment of human rights, including rights for women, should be seen as an aim of transitional justice. And I have to say how pleased I am that TGI in their summer school have made gender and transitional justice a core theme of its programme. The Commission has indeed raised the issue of the United Nations Security Council Resolution 1325, which demands the recognition by governments of the important contribution that women can make to peace and security in conflict situations. The lack of enforcement of UN 1325's resolution over the past 10 years has led to meetings this week of what are being called the Open Days on 1325, and they're taking place in 20 countries throughout the world as I speak. The outcome of these meetings will be communicated to the Security Council in October 2010, when each country, including the United Kingdom and Ireland, will be held to account for its lack of enforcement and indeed, or what it has done on implementing that resolution in terms of action plans that make these rights real in their own country. In Afghanistan, the Independent Human Rights Commission has ensured that their Chief Commissioner takes a leading role in monitoring and promoting the role of women. At the annual International Coordinating Committee in Geneva at the UN, which each National Human Rights Commission attends each year, including my own, the Commissioner Soraya Rahim Subram asked us for support in highlighting the absence of women at the recent peace jirga in Kabul. She is worried and has predicted that the talks between President Karzai and the Taliban militants could perhaps begin to erode the progress that was made on women's rights over the past 9 years. Like many prominent female human rights defenders, Dr. Subram every single day faces the possibility of attack or assassination on her life because she has stood up to defend the rights of other women. So the solidarity function which commissions play when one or other of us is faced with such challenges of this kind cannot be underestimated. Not only are the various committees of the UN used to highlight the country cases, but occasionally the Northern Ireland Commission will write in support of another commission, requesting a factual response to the inquiry. Recently, the Scottish Commission, the Equality and Human Rights Commission in Britain, and my own Human Rights Commission here in Northern Ireland had to write to the Uganda Commissioner in London, expressing our huge concern about the potential legislation to introduce capital punishment for same-sex relationships. This concern has been raised again this last month in relation to Malawi. Both the Irish and British governments have been called on to raise these concerns and have demanded that the parties in those countries that are pushing for such legislation be made aware of the country's opposition, both the British and Irish government's opposition, and even the potential of withdrawal of funding should such a law be introduced. Who was deserving of special protections was also an issue here in Northern Ireland, amongst a wide range of transitional justice issues. I've often compared these to the four wheels on a wagon. The first wheel was the effective governance piece, and establishing that took us a long time and only really began to happen in the last couple of years. The second was the law and order issues, which equally were as difficult, and I acknowledge the enormous role that Dennis Bradley played on this, who is sitting here tonight, in terms of the reform of policing and the reform of criminal justice, the decommissioning of illegal weapons, the demilitarisation of security forces. And the third was the institutional building, putting equality and human rights at the centre and establishing a Human Rights Commission and the Equality Commission and other commissions, as well as dealing with economic and social issues. And the fourth wheel, because each wagon has to turn on every one of the wheels, was reconciliation, potentially the hardest of all. The reintegration of prisoners back to the community, prisoner releases, the issue of victims, dealing with the legacy of the past, as we will know what that will feel like next week once again when Saville reports, and building and embedding a culture of human rights. The words of the agreement, which you all know, if you are from Northern Ireland, you will know these words off by heart now. They said it was going to create a new beginning. That new beginning was to start with the foundations of justice and peace, on the premise that if you deny people justice, they will deny you peace. If you create conflict and violence, then you will see your liberties eroded, and justice denied. Frustrate the right of the people to freely self-determine their future, and you have no right to expect their adherence to an imposed system of justice. So what this meant for the practice of human rights and peace building here was that only a holistic approach that addresses justice and peace together as mutually interdependent could ever succeed. The fundamental project of the agreement was to create a set of structures and institutions that people could have support in and have confidence in, accepting not just that the communal divisions between the two communities would remain, but also that two national allegiances and opposing political aspirations existed as of democratic right. The agreement proposed an agreed society, the basic features of which would remain, whatever the future constitutional status would be. So the right to be British, to be Irish, or to have dual citizenship was guaranteed, and the political structures, the deep reforms of policing and justice, and the establishment of institutions like the Human Rights Commission were designed so that everyone could have faith in the fairness and justice of the society that they were to live in. Some people still don't believe that we're in a post-conflict society. We're maybe in a transition from peace to conflict. But in any case, the human rights institutions have to be understood as part of that constitutional agreement, created often as they are today as a consequence of a peace accord. It may, in other words, be part of the system of checks and balances that underpin both the transitional process from violence to peaceful coexistence, and in the longer term, to the stable democratic institutions. On the one hand, when afforded a legislative and policy scrutiny function, which we in the Commission have, we can help to check the worst excesses of political power. On the other hand, it can, as was the case with the Human Rights Commission and, as Professor Barnett mentioned, the Bill of Rights process, to which I'll return later, we can be charged with specific tasks that input the very creation of the constitutional landscape. Central in any deliberations in many of the peace processes throughout the world have been questions around communities, the extent to which, if at all, they bear rights, and the ways in which, if at all, they should be included in the constitutional settlement. These questions aren't surprising, since it's in the name of community interests and the so-called cause that so much killing took place. We only have to consider our own context of British unionism and Irish nationalism, and the often perverted concept of what was supposedly just from a sectarian standpoint, to see how central the recognition and the protection of these identities can be. Here, the National Human Rights Commission can play a particularly important role, not as some kind of neutral arbiter or some impartial bystander, but rather as the guardian of what justice requires as a very minimum, or at least what is required in order to ensure that justice is required. First, it may be the case that the National Human Rights Institution uses its position to draw on international standards where appropriate in order to uphold the importance of institutions such as power sharing, which we have here in Northern Ireland, and is, we would now accept, a necessary reflection of political reality. Second, it can use its position when appropriate to act as a constraint, and we have had to do so, when, in a democratic system that enshrines communities as the principal political actors, that sometimes this can risk undermining the rights of other communities or individuals if left to run rampant. The issue of how to balance the right to parade, for instance, at the moment, has to be dealt with very carefully by not reducing the rights of individuals outside of the two communities to hold legitimate protests. And that's one example I'll return to later. Because of this difficult position, the National Human Rights Institution can come under fire, and indeed we have, from any number of sections of society. But in the face of such risks and within the delicate balance of conflict situation and constitution, a National Human Rights Institution can nevertheless, when suitably resourced and empowered, perform to some extent as a necessary counterweight that helps to ensure the rights of all are protected on an equal basis by that constitution. And in our case, that was the Belfast Good Friday Agreement. Let me give you an example of how challenging this job has been by reflecting, and perhaps the individual may have now changed their minds, but at that time, and everything in our process has been difficult, it has taken time, it has been piece by piece and bit by bit. But at that time, when Patton produced his report on policing, immediate response was this from one political leader: "To be told that we must accept the Patent Commission's report for the destruction of the Royal Ulster Constabulary is insulting. Indeed, it's an unconstitutional attack upon the democratic rights of the Ulster people. The law is to be changed so that the composition of the police force will be built in a quota system to produce a guaranteed 50% Roman Catholic force." Now, that was one of the most difficult issues, 50-50 policing. Even though it had a sunset clause built into it, where either it reached 30% or 10 years later it could be possibly the sunset would arrive and it would no longer be needed, as indeed has turned out to be the case, that this wasn't something that was helped to swallow this pill. And although we understood it as a piece of affirmative action, which is allowed in international human rights standards and has less frequently been given to women and ethnic minority groups, it wasn't seen in that way. It was and still is, unfortunately, referred to often as deliberate discrimination. Patent's programme was even seen as ethnic cleansing, and the Patent Commission was at certain times by parties seen as the death knell of policing. So as a consequence, when a national human rights institution tries to explain and clarify the importance of 50-50 and of affirmative action in situations as a transitional justice mechanism, it faces much opposition to this, and indeed that's carried over into other pronouncements it would make in the future on other human rights, and that was the case. As I noted earlier, it also fell to the Commission to carry out the training initially on the police service, and I know the University of Ulster was involved in that training and probably still is and will be for many years to come. The Patent report made it very clear that all police officers and police civilians should be trained and updated as required in the fundamental principles and standards of human rights and the practical implications for policing. Now, after the first few years, and Dennis Bradley was the Vice Chairman of the Policing Board, we took the view that the Policing Board was well established to hold the police accountable for this training, and that we handed that function over. Patent's recommendation, however, that the human rights dimension should be integrated into every single module of police training means that it's not transitional. It has to be consistent. It has to have oversight to ensure that this becomes common practice. And indeed, all credit must be given to Hugh Ord when he was asked, after he left his post and was handed over to the new Chief Constable, he asked, "What would you say to him?" And he said, "The lesson I learned in Northern Ireland was to put human rights at the centre of policing." So training and education of public servants, whether in the police or in the civil service, is an important function of national human rights institutions, as is our scrutiny of policy and legislation to ensure that compliance with human rights happens. This is essential in a conflict transition, as too often far too much emergency legislation is still left sitting on the statute long after it's no longer required. The Commission has had to comment extensively on this emergency legislation, including counter-terrorism measures, and it is able to rely heavily on the evidence from Northern Ireland to show what does and what does not work. As governments, both the previous Labour government and indeed the current coalition Lib Dem Conservative government, continue to say that they will roll out more and more exceptional measures to deal with the threat of international terrorism, the Commission reminds government that in Northern Ireland these exceptional measures at times were clearly seen not to work. And in terms of being compliant with international human rights law, many questions had to be addressed. Measures such as even today the stop and search single out communities as objects of suspicion. They have led to issues of community and indeed racial profiling on the basis of perceived belonging to one community, and in fact have alienated the very communities whose support was needed to combat the issues of terror in the first place. Despite the lessons here that these measures continue and go on to be used, and one still has to ask what was learned from the long period of conflict here in Northern Ireland. Moreover, the exceptional too often became the norm, and we continue to see this in relation to the issue of non-jury trials. In addition, legislative authorities must not be given space for the potential violation of human rights through the use of laws to deal with controversial issues. I mentioned earlier the parades issue. The parades issue has led at the moment, and indeed yesterday I was engaged with one of the leading political parties on this issue. It has led to proposals that would place disproportionate prohibitions on the freedom of assembly. The Commission has asked, and indeed we have been given some confidence in knowing, that this will be addressed and that amendments will be introduced to make that legislation human rights compliant. Both the international treaty bodies and the national human rights institutions have a hugely important role to play in this regard. The Commission, like other national human rights institutions, does have the power to take investigations into systemic abuses. As I said, if the Prisoner Ombudsman hands over her report next week to me in relation to the incidents in Maghaberry, and if there are systemic issues there, it will fall to the Commission to then make a decision to assess these. We can also go to court, we can take cases in our own name, we can assist victims in seeking redress. In our investigations on women in prison, for example, we not only made recommendations in relation to the issue of body, strip searching, and even the language that is used can tell you at times who is using which to describe this particular practice. Prison Service have insisted on the words full body search. Human Rights frequently refers to it as a full strip search. But also we have sought a judicial review in relation to the disproportionate use of this practice. These are difficult but important functions following a period of conflict. And whether the functions and the powers of any new human rights institution are accepted or welcomed, and often they are not, that's not the point. Indeed, it is very disconcerting for me at times to be told that I must go out and achieve cross-community consensus for any proposals on human rights, as if reaching a common denominator, and sometimes that might be the lowest common denominator, was some kind of a resolution or some kind of better achievement than the acceptance of the international human rights standards. In Northern Ireland, as elsewhere, there is also little political consensus, as indeed I'm sure Dennis would testify, on how we will deal with the legacy of the past. As part of any transitional justice process, governments do establish a range of commissions to deal with the historical abuses. Brandon has extensive experience of the South African Truth and Reconciliation process, and indeed the Eames-Bradley Commission was established here to find a mechanism for truth recovery and the investigation of deaths relating to the past. At the moment, these deaths are investigated by police officers through a historical inquiry team, and where there are allegations of state involvement, the Police Ombudsman's Office will investigate to ensure independence. As a result of these investigations, where there have been findings of state collusion in deaths involving lethal force, a new body, a further body, is now being considered in order to ensure that independence. The provision of independent, prompt, and effective investigations, which also involve the next of kin, has been a major focus of the Human Rights Commission's work. In fact, we took a case way back to the European Court, known as the Jordan case, in order to set the standards, and they're now known as the Jordan standards throughout the European community. Our concern is that having fought so hard to have those standards put in place, the Commission is now becoming very alarmed at the backlog and the delay in the legacy-related cases. Now, some of this delay, and I met with the Chief Constable last week, was as a result of the coroner asking the Chief Constable to release the documents from previously government-commissioned inquiries, such as the Stevens inquiry, and the Chief Constable being very reluctant on national security grounds to do so. Now he has been compelled to do so, and now the new Chief Constable has raised concerns about the lack of resources, because he said it will take a huge amount of public expenditure to redact these documents, and that in doing so he will reduce his capacity to deal with current policing demands. What I would say to that is that we do now know in Northern Ireland that a clear-eyed view of the past that identifies what went wrong is a necessary basis for building the future. This is why the concept that the Eames-Bradley Commission brought up in terms of a thematic inquiry is an appealing one to those who are now despairing that we will ever successfully get to the truth. That is where the issue of ethnic cleansing by non-state actors, or indeed the issue of security force collusion with criminals in intelligence gathering, can be dealt with. This approach would seem to be a type of collective right, rather than the individual right on which so much focus has been placed to date. Whether the process in the end focuses on the need of the collective or the individual, it does need to be built on respect for human rights and a determination to establish the highest possible standards for the future. It's only on that basis that dealing with the past can avoid reliving or recreating a nightmare. And indeed, I was very heartened to attend one of Brandon's Reaching Out programmes that Anne also attended recently in Belfast, where the communities had a great deal to say about their experience in terms of community development and how they could feed into much of the thematic issues on social and economic issues, for instance, not just the prosecution issues that had hitherto not been raised. In Northern Ireland, we have approached the issue of dealing with the past from a number of perspectives and have learned the lessons from elsewhere. From the wide and hugely influential groups on the ground, one of which Brandon is also involved with, such as Healing Through Remembering, the Pat Finucane Centre here in the city, WAVE, which has spread throughout Northern Ireland as a very strong victims group, and the most recently established Victim and Survivors Commission. It seems that for a long time now, Northern Ireland has been grasping with the question, how do we ever deliver truth to such a divided people? And how do we do justice to that truth? For other national human rights institutions, such as those in Latin America, the issue of the disappeared remains a long-running sore. And I know Roberta Pacic is here and who has done most wonderful work in producing the most beautiful quilts and tapestries to show the pain that still exists. Here in Northern Ireland, the Commission for the Location of Victims' Remains deals with trying to find and return these bodies to their families. And the Human Rights Commission, and indeed I myself have attended a number of these events, to know the cry to have those families returned, particularly in a community like ours, where Christian burial is seen as such a hugely important ritual. Again, we were involved in the Presumption of Death Bill. It sounds terribly technical, but what that did was allow those families to have the presumption of death so that they could finally get reparation for their disappeared. Reparation, in this case, also gave them recognition. A cross-jurisdictional problem can often arise in relation to the investigation of the disappeared, as well as a number of other troubles-related deaths, a problem that sometimes other probably national human rights commissions don't have to confront like we do. The Omagh bomb case, and indeed the Dennis Donaldson case, are two such examples. In the first case, the Commission joined with the Irish Commission in calling for a person of Judge Corrie's standing to initiate an inquiry into what went wrong in relation to the cross-jurisdictional aspects of the Omagh bomb. In the Dennis Donaldson case, the fact that Dennis was murdered in Donegal means that the Donaldson family are now having to fight to ensure that any inquest that could be held and will be held in Donegal meets the human rights standards for investigating such deaths, where there have been potential issues of state involvement, irrespective of which state on which side of the border was involved. Other national human rights institutions, such as those in Morocco and Sierra Leone, who I've met, have been given the responsibility for not only establishing, but also seeing through the implementation of the recommendations of truth commissions. We weren't given this responsibility. In fact, the Commission in Northern Ireland isn't allowed to have retrospective investigation functions before the year 2007. Indeed, it may have overwhelmed us if we had been given such a function. But in responding to this issue, the Commission instead hosted a conference in Belfast when I first took up my post to see how best we could assist each other in this process. We were aware that there were 33 truth commissions throughout the world, most of which were non-judicial and using restorative justice processes. The 2006 conference provided an opportunity for Professor Christine Bell to launch her book, Negotiating Justice, Human Rights and Peace Agreements. And that book provided a much-needed tool for many of the national human rights institutions to begin work throughout the world, because what they needed to do was to have an academic scholar put that material together from which each of us could learn what not to do or what worked, what was good practice, what could be amended or adapted to their own situations. Coincidentally, Christine's book was published by the International Council for Human Rights, which has just announced its new director as Mina Kai. Mina is a good friend of mine and was the former Chief Commissioner of the Kenya Human Rights Commission and was put under a death threat for undertaking an independent assessment of the presidential elections in Kenya, which was his responsibility. Fortunately, he survived that death threat, but he has told me that he will never be able again to hold a public position inside Kenya. At the request of Kevin Kelly last year, I went to Uganda. He is the Irish ambassador there, and he asked me to come with him to northern Uganda, where I could see at first hand the gross violations that had taken place in that country. I went to Gulu, and I went to the internationally displaced persons camp. And I sat under trees with men and women who had been subjected to the most appalling atrocities by the Lord's Resistance Army. I heard from others about the violations that were taking place by the Uganda People's Defence Forces, the government forces in Karamojaya. At this African Centre for Victims of Torture, I listened to the stories of men and women who were forced to hide for weeks in the bush so as to protect their children from kidnapping. Some pointed out to me their horrific machete wounds, whilst others spoke about being forced to eat body parts from a boiling pot. I met some of the Aboki girls there who had been taken away at night from their boarding school and forced to live as the wives of their kidnappers. Some have now had children and returned from the bush, but are so disturbed by the fact that they had to live for years with those who had kidnapped them, who were and had been the rapists, but also the fathers of their children. How do these women now cope with the return of these men? This week, in this last few weeks in Uganda, the International Criminal Court has had a review, and many of these issues have been discussed. Joseph Kony, the leader of the LRA, has refused to return, despite the commitment that he gave at the Juba peace talks. Whilst the demand for no impunity in Uganda has led to the establishment of an International Criminal Court, the three leaders of the LRA haven't been caught, so they can't be held accountable for the atrocities that they committed. The amnesty provisions agreed at those talks allowed for many to return rather than remain in the camps where they have become so heavily dependent on foreign aid. An entire generation, and I saw them for myself, of young people have been so deprived of education and so deprived of the opportunity to learn a vocation. The health services, the educational facilities, and the fundamental services are so sorely lacking in comparison indeed to what we have here. Many of the single mothers whose partners had been killed by the LRA, or who bore children, as I said earlier, as a result of rape, have been deprived of access to their own land and property because they no longer have a male relative. This is inhumane, and the abolition of this discriminatory practice has to be the focus of international attention. There needs to be a massive effort to inject new life and opportunities into that ravaged northern part of Uganda, and to give those reclaimed from the LRA a real chance to rebuild their lives. Vital elements that they have now recognised in Uganda include a genuine truth and reconciliation process to help diminish the trauma and the bitterness in Uganda. They also look for financial reparations to compensate for the destruction of their livelihoods and the well-targeted development projects to stimulate the local economy, all exactly the same issues that we have confronted here in Northern Ireland. So the Uganda Commission, like the Northern Ireland Commission, have years of hard work ahead if we are to go on addressing and even try to repair the damage that was done. A key difficulty throughout the peace process has been an issue that far too many individuals were given amnesty. In Uganda, many of these people were rounded up just before the Commonwealth World Conference was held there in 2007. And I had attended that as the National Human Rights Commissions were all coming together. But it was only after I left that I realised that all of these activities had taken place. The very last and final transitional justice mechanism that I want to refer to, and which other human rights commissions have also been involved in as part of their transition, is the issue of the Bill of Rights. I've hung up this beautiful quilt that I launched today in the Playhouse Theatre in Derry that has been made by the women from Gaeliach and Caw and Tullyally. They told a very funny story that it's the 13 apprentices, the apprentice boys that are often remembered in Derry, and they said, we are the 13 apprentice women who have stitched together this quilt for the Bill of Rights. And I pay tribute to them because if it hadn't been for the work of local communities throughout Northern Ireland, and it has been known as one of the largest community participation exercises ever undertaken, was this discussion on what kind of Bill of Rights would we want for Northern Ireland. 10 years ago, we were mandated by the Good Friday Agreement to offer the advice to government, and I produced it and we sent it in last December 2008. The Commission saw its work as a confidence-building, forward-looking project, but throughout this talk I've also led to the importance of looking to the past for guidance. The mandate that we were given was to be asked us to examine the particular circumstances of Northern Ireland in tailoring the Bill of Rights to our needs. And I understood that, as did all of the previous commissioners, some of whom are here, that this was to mean examine the past to establish what rights were particularly abused, threatened or contested, and therefore needed particular protection so that it wouldn't happen again in the future. I started the lecture by talking about the Belfast Good Friday Agreement, so let me finish with the same agreement. The agreement included the proposed incorporation of the European Convention and a Charter of Rights for the island of Ireland. It was subjected to referendum on both sides of the border and was overwhelmingly agreed and supported by the people on both sides of the border, under the watchful gaze of the international community, that very same community that now lauds Northern Ireland as an exemplar of how violent conflict can be successfully resolved. So it's a bit of a disappointment that a decade after that discussion started about the Bill of Rights, and now that we've stable government back in Northern Ireland, we, the Commissioner, are being invited to reconsider what the foundational document for protecting human rights in the United Kingdom ought to be and what it might include. Proposals to amend the Human Rights Act have created a sense of particular unease amongst those concerned to preserve and maintain the fragile constitutional balances that have been painstakingly put in place here in Northern Ireland. The Human Rights Act has been accepted as that foundational document, and since 1998 the Northern Ireland Commission has been busy, not trying to get rid of it, not trying to replace it, but instead attempting to build on it, as we were asked to do. The judiciary have been using the legislation effectively and have developed a very cohesive domestic jurisprudence here. A large amount of public money went into that training, and both the legal profession in its application and the public authorities in its compliance were put through all of that. So the suggestion that now after these elections, the general elections, the Liberals and the Lib Dems and the Liberals and the Conservatives have said that a task force is to be established to review the Human Rights Act, this somehow defies logic. Then add to this the notion that we've got to reopen up the whole debate and to start again to define, and in this case for a British Bill of Rights, what British values will mean. And this for us displays a total lack of understanding of the politics and the people of Northern Ireland when we had resolved so many of these value systems. It inevitably leaves us with some more bitter and divisive clashes, not less, and that's not a good thing to be happening at this time. The Human Rights Act is central to the constitutional DNA of the United Kingdom. It underpins the very devolutionary settlements which simultaneously elucidated the common values of the constituent nations. It also provided the necessary platform from which the sense of our own autonomy that devolution can bring, and that we could build on this. The importance of this dual understanding cannot be overstated in this part of the United Kingdom, where identity politics has too long gone hand in hand with sectarian politics. For anyone who wishes to consider tampering with the Human Rights Act, I want to send out a strong message. Nowhere in any part of the world has the repeal of existing human rights protections been seen as a starting point for discussing a proposed Bill of Rights. We in the Commission started our work with do no harm. The United Kingdom, particularly given the huge complexities constitutionally that now exist as a result of devolution, shouldn't even attempt to set up such an unedifying precedent. The Human Rights Act 1998 must be defended and built upon as part of further progress in the promotion and protection of human rights within and across all our jurisdictions. To do otherwise from a Northern Ireland perspective is to invite a very unnecessary and unwelcome discord. So there are good lessons and there are still lessons that we have to learn. In conclusion, the national human rights institutions in countries now coming out of conflict have used a whole range of mechanisms to assist in the development of a sustainable peace process. As I've said throughout these talks, that they have gone from monitoring to investigating to litigating to training and educating, through to holding inquiries, scrutinising legislation from human rights compliance, and indeed even a Bill of Rights. A national human rights institution cannot do any of this without the support of the people on the ground and without the assistance of many of the NGOs who are here and the human rights organisations who have for so long raised these issues as being important to the future of Northern Ireland. Those relationships were built up during our peace process and they often demanded courage, creativity and risk-taking. As John Paul Lederach, who would be known to the Transitional Justice Institute as someone dealing with conflict resolution, and indeed to INCORE, and he has visited here, has often said that people living in settings of deep-rooted conflict were faced with the most extraordinary irony. Violence is what we have become so accustomed to, so what happens in a peace remains a complete mystery. But the seeds have to be planted if we are to embed a culture of human rights amidst all the uncertainty that we're facing, and sometimes the uncertainty that is brought with that transition from conflict to peace. And we know there are still those out there at the moment who don't believe that this transition was a good one, and have sent us messages back to us that they do not wish us to live the way that we intend to. Whether it is for the people of Afghanistan or the Middle East, or the people of South Africa or Uganda, or the people here in Northern Ireland, for all of us, human rights has to be meaningful. We have to believe in the worth of human rights. We have to believe in the institutions that have been built up to defend them. We cannot give up. There is much still to learn about the role of human rights in peace building that will keep our commission and many other commissions working for some considerable time. Let me end with the very powerful words of the African-American poet Langston Hughes. He says this: "Gather out of stardust, earth dust, cloud dust, storm dust, and splinters of hail, one handful of dream dust, never for sale." Thank you for your attention.
Well, thank you very much for that, Monica. I'm very glad that the lecture has been videoed, because I sort of feel I need to watch it again to take in all the areas that you covered. And I suppose covering a wide range of areas in terms of placing the issue of human rights within the centrality of peace processes is very important to us and to the Transitional Justice Institute. And I think particularly the way you covered such a wide range of issues, you know, from transitional justice through to domestic violence, through to international comparison, disappearances, a whole range of issues. And it certainly provides us with an enormous amount of food for thought. So thank you very much for that. And I think I just want to also add that not only the sort of intellectual power that you bring to that, but also the compassion and the sense of equality and fairness, which I think is so important in this area. So we have about 15 minutes for questions, and Monica has very kindly agreed to take some of those. So I'll take a few questions, and I'd just like to ask people, because we're a little bit short of time, to maybe keep their questions as brief as possible. So I'm going to start over here, and then I'll come to you after that. So.
I think what I'm going to do, if it's okay, is maybe take sort of three questions, and then you can respond to them so we can get a few more in. So I'll take a question from yourself. So, Mike.
Thanks very much for your enlightening facts and talk. First of all, Dr. Interesting I'm involved with Foil Multicultural Forum. First of all, I would thank to our Sir John for bringing peace in Northern Ireland. He played a large role in it. Now, coming to the point, peace process is here, and it's nearly, to me, it's nearly bringing fruits up. Question to you is, what do you think? Are you optimistic it will go further like that? And further, what statutory role, I know you mentioned about fortnight, to force people to do with human rights, or internationally you have input, or have you sent anybody, or anybody has come to you to take your advice how we are dealt in Northern Ireland? And lastly, ethnic minority question, I think, and because I belong to Foreign Multicultural Forum, which is our thing called since 2007, and in our inauguration in 2008, it was very delighted to see our Deputy First Minister here, Mr. McGuinness, standing beside the police. I was with them, and law and everything has been transferred up to us. On ethnic minority, I think they haven't suffered anything much around. In our Zealand, that's my view. And
Thank you very much. Is there another question?
Where would I begin with this question? Is a very good question in terms of what I've seen elsewhere, what works. It actually takes a very powerful government to give the powers to a national human rights institution to monitor what happens in the military establishment. And I was very impressed that Uganda has it. However, the Commission must actually use those powers. And I was also very interested to see that there were some commissioners on that commission who were very opposed for the Commission to use its powers against the government, because the government had actually appointed some of these commissioners. And so that's a really delicate issue, to get the powers and to use them, but also to make sure that you stand up in the face of that opposition when you do use it. A lot of countries actually don't like bills of rights. It may be one of the reasons why we don't have one, because it is seen as anti-majoritarian. And therefore, to introduce a bill of rights means that it's a very powerful thing to do as well. But I just wish that we would hurry up and get over this problem in relation to Northern Ireland. It's one of the outstanding pieces of the agreement. It's going to happen. It has to happen. It was signed up internationally. And so just to send us round and round in circles, that there may be a UK agreement, or UK/British Bill of Rights, and that some rights will be added on, that will be the resolution, will clearly not be. And so people need to stand back and say, we've come this far, don't be putting more obstacles, let people get on. People are getting fed up with it, and really want to see it. I also would like our Commission, and indeed other commissions would say the same, to be respected as an independent authority. I have to actually, I met John Dowd yesterday, the Sinn Féin MLA, who has been engaged in this discussion. You might have seen him on TV recently with Eamon McCann, engaged in the debate around the legislation of parades. The one thing that struck me was that when Eamon and Noel Thompson were saying, Human Rights Commission have complained. Now the Commission doesn't complain. The Commission makes submissions and actually raises the issues. Some people might see them then as complaints, but we are statutory authority to do that. And John Dowd, for the first time amongst many of the politicians, actually said, the Commission is entirely within its right to criticise us. And we will take on board what the Commission says very seriously. And that was the first time I'd heard a political representative say that. And I must say it gave me a bit of heart to stand back and say, now I wish more would say it, because commissions as transitional justice mechanisms and as independent commissions with statutory authority need not to be disrespected, diminished, have their voices undermined when they do stand up and say, whichever party, and in this case it happened to be their party, were being criticised. And it was good to see that party saying, yes, they've criticised us, it's their right to criticise us, and we need to take seriously that criticism. And we need to go back and look at whether we have to make an amendment in order to make the legislation more compliant. And that was a really good thing to hear. But we have come a long way. And I have no doubt that initially, I have to say it again, that the Commission hadn't got very many powers at all when Christine was on the first Commission. You didn't have the powers to access places of detention unannounced. You went to the courts to get it. Unfortunately, one of the judges ruled that the Commission could and should enter the prisons, but it shouldn't have taken the Commission to have gone to that length to get it. And so there are people very nervous about letting oversight bodies into their establishments. We went further when I came into our Commission and asked not only for the access to the places of detention, but also to have it not fettered. I don't think it is good to have 15 days notice, because if there's something terribly wrong inside a mental health institution or a place, at the moment our investigation is into the rights of older people in nursing homes with dementia. Well, there is no point in us telling every home that we're coming in next week or the week after. Our investigators are in at the minute, after midnight, through the night, observing what is happening in the homes that we have picked randomly in order to do our investigation. Now, they're able to do that because we declared the investigation, gave our terms of reference, and were able to go in. But we had to give 15 days notice before we finally get all of this agreed. My next step to the government is to say, lift this 15 days. Fortunately, the Chief Constable, Hugh did say to me, go into Antrim Police Station. It's really important that the people here, when you come out of Antrim Police Station, that people aren't being tortured in there, given what had happened in terms of people's memories. And Hugh understood that he could have asked me to wait 15 days, and by that stage, actually the next day after I did make the visit, they were all released. Because it was going from 14 to 28 day detention without charge. A number of them were rearrested. But those are important issues, to be able to respond at moments, to use your powers sensibly and not to duplicate. And I think it would be really important to get some of our powers lifted where we are being stymied. So basically my answer would be, yes, we've come a long way, but I really wish that human rights could be seen as universally accepted as a strength and not a weakness. It must be rights for them, so it can be rights for us. And for that mentality is still existing here. And I sincerely hope that people prepare themselves for next week to ensure that that doesn't happen when Saville produces his report. In relation to the issues of the jurisdiction, I think, Christine, your commission commented on the Iraqi war, and your commission, I'm saying your commission, when you sat on the first commission, when those commissioners pronounced that the UN had been bypassed in making that decision, it was quite within its rights to do so. But again, came in for an awful lot of criticism that what was the Commission in Northern Ireland doing, commenting on what was happening in Iraq. And we are therefore only meant to comment on what happens in the jurisdiction of Northern Ireland. But what we can do is lend ourselves through our International Coordinating Committee, because we are affiliated to the UN. And in order to get affiliated to the UN, we had to show how rigorous we were, how independent we were, and then the UN comes and assesses you and allows you to be one of its current 70 affiliated bodies. Well, that's where we have the power to raise those questions that you asked about if someone from another country comes to the Commission, highlights a real serious concern back in their country, then I cannot say to them that I can immediately go here in our jurisdiction, but I can raise issues with their High Commissioner, or indeed through the International Coordinating Committee. And that's how we kept Monica alive, because we did tell the Kenyans and the Kenyan government that we would be watching every step of the way if anyone killed them. And that oversight and that solidarity function was extremely important. There are thousands come to the Commission for help. We can't assist them all. Many of them are human rights cases, so we have very strict and rigorous criteria in showing the people here what we can assist. And certainly It's very interesting for me now that many of the issues that we're being asked to assist on are no longer to do with the Troubles. They're to do with migrant workers, they're to do with immigration detainees, they're to do with older people in detention. And so that's an interesting move from when the Commission would have first sat in its early days to the work that we're mostly focusing on. But the past hasn't gone away. We're now developing our new strategic plan, and much of it will still be dealing with the legacy of the past. But in having said that, we will still also be dealing with these modern day democratic issues that any Human Rights Commission should also be attending to. And so it's a combination of those two that I think for many years we'll still be working through. Christine and I were talking earlier about how much of this is going to take up our time. And I think it was John Powell Lederach Brandon, if you remember, who said that it will take you as many years to come out of this conflict and to deal with all the issues of this conflict, which means 40 years, as the years you were in it. And so this Commission may indeed be focusing for some considerable time on these issues, and as a consequence political parties don't like that and will continue to wish that we were doing other things. But a Commission worth its salt has to respond to these issues, as well as to be able to show that it is able to look to the future and take on board some of these serious issues, like the rights of people with dementia in older people's homes. I hope I've gathered up at least some of the questions that you asked me to address.
Thank you. I probably should have introduced myself. I'm Brandon Hambert, the director in INCORE. In case you were wondering. I'm going to take one more question because we're up at 8 o'clock.
Thank you. My name is Nassiman from the Romanian Peace Organization, and would like to ask you what, because you referred to the human rights role in peace building. Part of peace building is that it's a long-term engagement that requires a lot of sustained support, and not only in capacity and in mandate, but also in financial commitment. So what is the state of the commissions, of the Human Rights Commission with respect to the financial commitment and current financial support, I guess?
It's a very interesting question because it actually goes back also to this bill of rights issue. Should you put most of your focus on political and civil rights, or should you also be looking at the rights of social and economic rights and cultural rights? I'm sure in Romania these have been important issues. It was quite interesting that it was the Soviet and Eastern European countries back in 1948 who pushed those rights when the Universal Declaration of Human Rights was being developed. And it was the West that said, no, we only need to focus on political and civil rights. Well, whatever my work on human rights has taught me, it is that you can't deal with one without the other. They're all interdependent, as we know from our identity rights, our cultural rights, our social and economic rights. And actually somebody had the sense from the Gaelic group to put the environmental rights, which is the rights that our kids care about in relation to sustaining the future. So for every country, the focus is depending on what age you were and where you came from at a particular time, which right you saw as most important, and indeed, depending on how vulnerable or marginalised, which right you see as most important. And people in the peace process, and women in particular, and ethnic minorities in particular, focus on the issue of security and safety from a social and economic perspective. And it's often the combatants and political prisoners and others and political parties who deal with it, security issues from a political and civil perspective. And it's only if you bring those together will you have a sustainable peace process. And I think Brandon's work through the INCORE showed that in that meeting, that if we don't attend to issues of education and the health issues and the trauma issues and the mental health issues in particular that people here know so well about, then we can't truly say that we're making reparations. If we simply talk about reform of the justice system and lead to more prosecutions. And I think Dennis Bradley, when he sat with his colleagues on that commission, that's exactly the point that they were trying to make. That we shouldn't simply be looking and putting more and more money, perhaps into our courts. And as a Human Rights Commission, I would say that's extremely important, that justice is served in that way. But if they're also making true reparation to a community that has been so damaged, you have to look at these issues of social and economic progress and what's stymieing and stopping that as well. And I think, if we don't show that we're able to do this, and this is the question for people working in human rights as well as the people working in democratic rights, constitutional rights, is that the dissidents will perhaps say to us, you got it wrong. You never were about being serious about making this a sustainable process. Now that's not actually the kind of message they're sending us, but one of the messages that they tell us is why are so many of these disenchanted, disenfranchised 17-year-olds prepared to join up? And if we don't make this society meaningful for them, then they will kind of go back and romanticise the alternative as deconstruction and very serious kinds of activities that they're engaging in as some kind of the alternative to getting the process right. So it truly is something that we have to speak to those young people and make their lives meaningful, indeed as the university here also knows about. But at the same time, as I said, it is peace and justice, and it's human rights across all those fronts that we really do have to attend to. And there isn't a great deal of money about, but some of this stuff doesn't require money, big resources. It requires a change of thinking. I know that from the work in the prisons, that sometimes, and Dennis will know this from the work in policing, that it didn't require huge amounts of money to do what they needed to do to really make the institutional differences. What it did require was a change of attitudes, or as John Hume always said, a change of mindsets. And that actually is about education and about information and showing to people that if you do have that change in your heart and in your head, that's the kind of improvements that you can talk about, and that's the kind of society that truly means people begin to be at peace with itself. So Romania, of course, is going to have these difficulties in terms of where it finds its finances to deal with the deprivation and the impoverishment and the damage that was done, as we too had. And we were very fortunate in the European Union poured so much money into helping us in that peace process. But as many of the NGOs and communities will tell you here, the hardest work of all was on attitudes.
Okay, well, thank you once again, Monica.